All right, so the judge took those arguments under advisement and said he will make a ruling at a later date, and of course we'll update you as soon as he does. Let's bring in our guest for this hour. Joining me to discuss is national trial attorney Michael Jaafar. Michael, great to see you. Thank you so much for joining me on the program. Now, this is an interesting situation. I think it's clear. As you heard, 14 pages of content on social media, including videos, very disturbing videos that I think, if they're presented to a jury, could cause problems. They range from 2016 to about 2021 or so. Apparently, the one that was put out in 2016 actually talks about cannibalism, which we know is an issue in this case, also talks about beheading, which is an issue in this case. So the state is claiming it's intrinsic. Once you make that argument, you don't even have to get to the prejudicial part because it's intrinsic to the case, because it sort of mirrors the facts in the case. So let's start right there with the videos from 2016, where she's talking about cannibalism, and beheading. What do you think the judge might do under those circumstances?
That's going to be a tough one. The decision that the judge is going to make, this is why we have the system that we have. The judge knows that by allowing this evidence in, this woman's pretty much convicted. This is going to be the toughest decision. What do I think the judge is going to do? This is a tough one. This is a coin flippy type of decision, but I think the judge is going to let it in. As a defense attorney, I just don't think it should be let in because that's the end of the case before the case even starts.
All right, so now we got these other videos going from like after 2016, going all the way to 2021. I think the argument that it's intrinsic, and I don't think the state is even making that argument. You can't make that argument. But they're saying it's probative. We want to bring it in. The defense is saying too prejudicial. We're looking at one of those videos made in about 2020 or 2021. What say you on that? The idea that, again, I think these are so prejudicial that I think the probative value is far outweighed by the prejudicial effect on a jury. So what do you think the judge might do with these videos that came after the murder in 2016?
If I was a judge, I would be looking to see whether or not the defense attorney admitted evidence that she has changed her views between the time that those videos were shot and the time that the murder happened. I don't think that was introduced. That would make the judge's decision more difficult. I think the judge is looking for anything that says this was in the past, this was behind her, she's changed her life. Because then at that point, they would not be probative at all because this was a prior life that this woman had and prior views. That didn't happen. So I think, again, I feel like the judge is going to let it in, but I just don't think it should be let in.
Yeah, I agree. One of his questions concerned me. If I was a defense attorney, it would concern me. And he says, she's also claiming, right? So the guy who, her boyfriend, is claiming that she told him or asked him to do the killing, and it was really her idea. She's claiming she was under his influence, and that's going to be part of her defense. So the judge is asking, look, does it rebut that claim? Are they allowed to bring it in to rebut this idea that this wasn't my idea, I was under his influence, but yet here I am posting these kinds of videos? I think the state has a decent argument there in that case.
The state has more than like a very decent argument, and that's why I think the judge is going to let this in. For me, just the sanctity of the system is when a trial is over before it even starts. What if this woman didn't do this? What about the chances that she didn't do it? You know, she loses that. It's basically she's collaterally stopped in the minds of the jury from saying that this is not who I am because all this stuff was admitted. So they have a great argument. It's just, man, the case is over the minute the judge lets that in.
Yeah, I can't agree more. So I think, Mike, if you're representing her and the judge lets this type of evidence in, I mean, this is part of the job of the defense attorney. You got to try to get it out. But if he lets it in, do you then start talking to the state about a possible plea, maybe trying to get it to some date for her to possibly be paroled?
That's exactly what I would be doing. I did the analogy yesterday. The amount of time between now and the JFK assassination, that's the amount of time that has lapsed between now and then. That's how much time she would be facing in prison if she were convicted on these charges. It's an eternity. So if I was a defense attorney and this is the case, I'd be arguing the case right now. This is where I win or lose the case is right here. I don't even win by winning. I just don't lose by winning.
Yeah, I would agree. All right, Mike, stand by. It's time for us to take a quick break. All right, interesting stuff there. Let's bring back in our guest still with us to discuss national trial attorney Michael Jaafar. Michael, I got to say, yesterday when I heard the testimony of her text messages, and I have been waiting in this trial to find out what connections they had with this girl, with this gang, so that they thought she might have been a part of this, because as far as I've heard, the information and the evidence is kind of lean. when I heard those texts, it changed my view of her, right? And I said, okay, these are 3 years before, and the cross kind of brought me back and said, look, that's just folks talking about what's going on in the neighborhood. There's a lot of chat going on, a lot of gossip, and you may say things that you don't really mean. So it kind of brought me back a little bit. But quickly, let's talk about those texts that were 3 years, where she's talking about, oh, that murder that happened at her school, and Julio Foolio's this, that, and the other thing. What did you make of that? Should that have been let in, and how probative is it of the fact that she may be a little bit more than meets the eye as far as this gang is concerned?
It absolutely should not have been let in. I think it rises to the level of potentially appealable error. I don't know why the judge would let that in. And yes, it did change my opinion of her. I gave the example yesterday of how much time she'd be spending in jail, and she was a kid. She was even a bigger kid back then, just 3 years ago. I don't even know how much of her brain was not even fully developed. And because it also changed my reflection on her, these were private text messages that clearly had nothing to do with the murder that happened 3 years later. So why the judge let it in? Big mistake. I think it was very prejudicial. It had very little probative value. What was the point? That she's the type of person who will 3 years from now drive people to kill him at the Holiday Inn in a parking lot? It's ridiculous. It's absurd.
Yeah, now, it could go similar to what we just saw, Mike. It could go to the argument that if she's claiming she was only there because she wanted to go along with her boyfriend, who was a bit hostile and threatening, et cetera, and we may even hear that he abused her if she decides to take the stand, that kind of evidence refutes that idea that she didn't know what was going on, and that when they're out there and they're talking about this guy and they're driving around looking at this guy, she knows exactly what they're doing or what they're out to do because she's involved in it, she's talked about it. Not that she maybe wanted to do it, but she knew what was going on.
That's a very insightful way of looking at it, and that's what the prosecution said, and they clearly won the day, and the judge clearly went forward with that. For me, it's so prejudicial because it was 3 years ago, and because that's how kids talk. They were calling each other the B word in those text messages, but they're friends. It's just a different lingo, different vernacular, but their life is small. Like, people have to look at the lifestyle that they were living in, and the world they lived in was so small, and this was everything they had, and they just talked about it. I'm sure there was thousands of text messages she exchanged with that friend about other people and other gang-related issues that she had nothing to do with. But clearly, the way you just laid it out is what the judge was convinced by.
Yeah, and finally, just quickly, I got 20 seconds, Mike. Now they're trying to get something that's even further in the distance. Do you think the judge said, okay, look, I gave you a win here, I'm not going to give you that one. What do you think he'll do with the 4 years?
I think he'll say, no, I don't want to get appealed and have it be brought back. I already I walked down the plank enough for you guys.
Yeah, I would have to agree with that. All right, Mike, stand by. All right, again, that's on Monday. Let's bring back in our guest with us, National Trial Attorney Michael Jaafar. All right, Michael, let's start with Bianca Ellis. She's being sentenced on Monday. The jury in that case obviously rejected her claim of being insane at the time that she committed that murder. How is that going to play into the sentencing hearing, or will it? Because, again, it's been rejected by the jury. Now the judge is going to hear a lot of evidence again about her issues with mental health.
They're going to lock her up and throw the keys away. I think that this is, kind of a sad part of our system. By rejecting her plea, they actually gave her what she wanted. Somebody who has bipolar and schizophrenia does not want confirmation that they have it. They don't want to be found not guilty by reason of insanity, because what that would mean for them is a lifelong of being forced to take injections, which are painful, which create lethargy, which make you lucid, and you have to contend with what you've done and the monster you are. By rejecting that plea, she's going to be thrown away with the key's going to be just thrown away, and she'll be in general population, and she'll believe that she didn't do anything wrong.
But Mike, let me ask you this. Now, she's diagnosed with schizophrenia. I mean, there's no question she has it. They just didn't think that's what she was sort of blacked out with, that kind of schizophrenic episode, or whatever you want to call it, at the time of the murder. So when she's put in general population without medication, she's going to be a danger to everyone. We do know, according to the defense, that while she was at trial, she was taking very serious schizophrenia medication, which was injected. So I would imagine the same thing's going to happen in prison, or is it not?
She will have more liberty about her medical treatment by just being in general population. And the people who are going to be punished are the other people in prison, because at the end of the day, not everybody in prison is there because they're a monster who murders somebody. There's people there for 5 years for making a mistake the worst time in their lives. They have to share a room with this woman, general population with this woman. So at the end of the day, it's going to be terrible either way, but she's going to have more liberty about her treatment by being in general population.
All right, fair enough. Again, that comes up on Monday. I want to talk about Abby Zwerner now. Remember, she was the woman who was shot by a 6-year-old in her classroom. Now, she had to get over a hurdle because the schools were claiming, and the school district was claiming it was a workman's comp case. She got over that hurdle, claiming that, of course, this is not in the normal course of business of being a teacher. But the school, right now, they're fighting this, but they were warned that day, Mike. What do you make of this case? A couple of different people told them that there were issues. This kid had long-standing issues. As a matter of fact, his education plan required a parent at the school with him during the day. The parent couldn't make it that day, so she wasn't there. What do you make of her case against the school district?
First of all, I'm very envious of the attorneys representing her, because I wish I get cases like this. What I think about this case is that she, the workers' comp was not her exclusive remedy. I would be shocked if this trial moves forward. I think it would settle in the next 3 days for an undisclosed amount. She's right. Her attorneys are correct. The judge made the right decision. There's no way that a teacher signs up for being shot when they show up to, because what they're saying is just like you slipped and fell at the school, you can only get workers' comp, which that would be the case. She got shot. They had warning. Her defense attorneys convinced the judge that there was gross negligence. You can't, if you're a school administrator and you have this type of evidence, you cannot ignore it and then look at the harm that you're creating to people that trust you.
Yeah, I would have to agree that the standard is the employer must expose the employee to a heightened risk of the accident that caused the injury. I think this is one of those that clearly fits in, so there just may very well be some sort of settlement. All right, Michael Jaafar, we'll be watching closely. Thank you so much for being with us tonight. Always a pleasure to have you on the show, my friend.